is one of the very few occasions in my life that I have rather seen the prosecution and the bench insist on the right of speedy trial and accused persons and their lawyers are saying, no, don't try us so fast, we want to delay. Just imagine that the lives of their clients were in jeopardy in one way or the other. Would they not be rushing to the courts to ensure that the right of speedy trial is enforced? The people of Ghana are listening, the people of Ghana are watching, and the people of Ghana are making their judgments about who is protecting their interests and who is taking them for a ride. Most of the judges sitting on the Court of Appeal, sitting on the High Court, and sitting in the Supreme Court may be the appointees of the New Patriotic Party administration. I haven't done the thorough check. But for example, when I look at the current Chief Justice, if you look at his career, his appointment follows a certain trajectory. You understand? When did he become a High Court judge? When did he become a Court of Appeal judge? When did we graduate to a Supreme Court judge? And if you do that carefully, you might find that the most important appointments in his judicial career happened when the New Patriotic Party was in power. How does he then become a poodle of the National Democratic Congress?
Kwesi Pratt Jr. Akasa on a Pan-African TV, Alaji and Alaji. Now, I say, in fact, what the air court cases be brave achieve. Now, this is the first time in history. Yeah, judge, yeah, alternate cost a case be so etchese. Me pese me di a case no ewie intentem. Na a judgment that war no ye the ball. Say we be for and I say we be the bim. Anything avail yourself for a year the case. But the lawyer for a year client standing against the lawyer say no, ye pese ye delay tactics. Ye pese would delay case and so forth. Best 4 months and sana a year will pass a judgment. And Kwesi Pratt Jr. just a journal one on Tiasio. Now, we need the first time one sa deal with. In fact, Kwesi Pratt Jr. is silencing a NPP Jandam on attacks on CJ Bafuboni, the judiciary, any offense no legal vacation a saga. Now, as usual, Kwesi Pratt sending Okasa with facts and information unbiasedly or analyzing a year. The matter at hand no ama wonso wanya entiasia on a asema oka if you are not wearing a political lens. Now yenti the details from Kwesi Pratt Jr. Higher PENDREAM TV. Subscribe to the channel, bell notification na share ma afofro ensa enkabi. Comment section or constructively now the kwadwentre.
Manever I say ma PENDREAM TV. PENDREAM TV there o see them yopo.
Is it Pratt?
Well, I mean, look, the point has been made. And first and foremost, I'd like to commend our fellow panelist Mujib for always, trying as hard as he can to speak the truth as he understands it. I mean, this morning, he has made the point very, very strongly that as far as he's concerned, and in spite of his membership of the New Patriotic Party, the Chief Justice has not erred in law in this matter. And I think that that's a very commendable, position to take. You understand? Now, having said that, I'd like to draw our attention to a video which was brought to my attention in the course of the week. And that video is instructive in the discussion of any matter now, especially in the discussion of what appears to be controversies between the New Patriotic Party and the National Democratic Congress. In the course of the week, I saw this video in which a former NPP member of parliament, who is also part of the communication team of the NPP, addressing NPP communicators in what looked like a seminar designed to, shape up strategy for communications. And he made very, very strange statements. One, he says that, look, Parliament is a house of records. And therefore, in Parliament, facts matter. You understand? That they cannot expect members of the minority to go to Parliament and use Parliament House as a platform for propaganda. But he said the NPP headquarters is not a place of records. So as far as the NPP headquarters is concerned, facts don't matter. And that all they have to do as communicators is to constantly turn out propaganda which will make the government jittery, which will make the government always run to respond and so on. That facts don't matter. Now you see, if this MP has said this and had been booed by the communicators, it would have sent a different message. Even if after saying this, the communicators did not react, it would have sent another different message. But Sana, when this MP, former MP, said that facts don't matter as far as the NPP is concerned, he had resounding applause from the communicators. I'm frightened by this. This is worrying. Now, the resounding applause by the communicators meant approval. So imagine a political party which is shaping its public communications on lies and is able to admit that. That's frightening. That undermines all the tenets of democracy. You understand? How are you going to deal with a party which has decided that facts don't matter? And I'm surprised that this video has not been played over and over and over again. Because it's the most damning statement ever to be made by any politician, that facts don't matter. That if you are discussing anything, don't look for facts, just look at what is dirty. Pour it out on people you perceive to be your opponents. Make them run, make them, agitated by spreading falsehood. Facts don't matter. So you see, when we come to discuss all of the issues, including the one before us, we must do so from the position that there are some people in our country who have come to the conclusion that facts don't matter. And that if you continue repeating facts, you are wasting your time, because for them, facts don't matter. This is a very important video. You understand? But let's put that aside. You see, all of us, whether we are in the New Patriotic Party, Convention People's Party, or the Socialist Movement of Ghana, whatever, at least we put on the pretension that we are interested in the protection of citizens' rights. But you see, in our public discourse, in discussions of issues and so on, sometimes our attitude betrays the fact that we don't think that some segments of the population have rights. And it's very, very dangerous. Sana, every citizen, every one of the 35 million people of Ghana, or 36 million people of Ghana, has rights which must be defended and protected. Everyone. Including the president, including the vice president, including parliamentarians, including teachers, including lorry drivers, and so on. So therefore, judges also as citizens have rights that we should be interested in protecting. The judges who sit on the High Court, the judges who sit on the Supreme Court, they are not aliens. They also have a right, they have the rights which are enshrined in this constitution, which every Ghanaian citizen must enjoy. Okay? Now, what we have to understand is that some people are lawyers, some people are blacksmiths, some people are farmers, some people are members of parliament and so on. Because all of us 35 million or 36 million people cannot do the same job. So we are talking about essentially a division of labor. Somebody is a judge, somebody is a soldier, somebody is a policeman, simply because societies now at this age function, on the basis of the division of labor. Now listen, if you say that judges, blanket statement, judges are poodles of government, what are you saying? You are attacking the integrity of judges. You understand? If you say that judges are delivering political judgments, some have even gone to the extent of saying that some judges take direct instructions from the Jubilee House and so on. Now, if you say that, it's an attack on the integrity of the judges. And an attack on the integrity of the judges, without facts, without proof, is a deliberate subversion of the rights of judges. Because we are destroying their reputation. Yes, sir. You are saying that they have no mettle. They are poodles. They don't think on their own. That they are actually violating their judicial oath. That they are dishonest people and so on. That's what you're saying. So you see, when political parties get up and make glib statements, and these statements are really glib statements that a certain decision is political, a certain judicial decision is political. What are they saying? What are they saying? In any case, what is the basis for saying that? Because I can bet my bottom peswa that most of the judges sitting on the Court of Appeal, sitting on the High Court, and sitting in the Supreme Court may be the appointees of the New Patriotic Party administration. I haven't done the thorough check. But for example, when I look at the current Chief Justice, if you look at his career, his appointment follows a certain trajectory. You understand? When did he become a High Court judge? When did he become a Court of Appeal judge? When did we graduate to a Supreme Court judge? And if you do that carefully, you might find that the most important appointments in his judicial career happened when the New Patriotic Party was in power. How does he then become a poodle of the National Democratic Congress? I just wonder. Now, I'm not saying that because a judge is appointed by a certain regime, that judge's decisions must be necessarily colored, politically colored by that regime. But I'm saying that if that is your argument, at least it has to have some basis. And I don't see any basis. I want to emphasize that the reckless and baseless attacks on the bench ought to stop if we truly want to build a democratic order. This is not to say that all those who sit on the bench are angels. They are not. At least we saw the Anas Arimuayao revelations and so on. So they are not angels. They make mistakes like all of us. They are human like all of us. Their judgment may be misdirected and so on. But you don't make statements that envelop all of them in indignity, without basis and without proof. And I think that, look, the New Patriotic Party has been most unfair to the bench in this country. Most unfair to the bench in this country. And it's important to take note of this unfairness. Now, the third issue I'd like to address has to do with the Ghana Bar Association. Ghana Bar Association. What is it? Clearly, the Ghana Bar Association is supposed to be an association of lawyers. Okay? An association of lawyers in good standing. Well, in good standing means the lawyers who pay their dues and you know, accept other obligations imposed upon them by the association. The Ghana Bar Association is an association for all you care. It is under the law, it is an association like the Brekum Widows Association. That is what it is. Okay? Now, when the executives of the Ghana Bar Association issue a statement, what is the value of that statement? What's the import of that statement? And to test that, let's use the program this morning. Sitting on my left is a lawyer, Lawyer Apia Dankwa. From the presentation he has made this morning, it is clear that the Ghana Bar Association did not speak for him when it issued that statement challenging the decision of the courts to sit during vacation. Now, don't forget that the Attorney General is leader of the bar. He disagrees with the Ghana Bar Association. And over the course of the week, I've heard many lawyers disagreeing with the position of the Ghana Bar Association as expressed in the petition signed by its president. Now, there's no way of finding out whether the majority of lawyers agree with the position of the Ghana Bar Association or not, apart from actually taking a head count. You understand? Because there have been instances in the past when the Ghana Bar Association has taken positions, and that position had actually been discussed and voted upon by less than 10% of the membership of the association. So we should not be deceived that anytime a statement appears or claims to be emanating from the Ghana Bar Association, it speaks for all lawyers. It cannot be true. It speaks for those who technically, and I mean technically, have the mandate to speak on behalf of the association. I hope you understand what I'm saying. So we should not be confused at all about what the Ghana Bar Association has said in this matter. Now, the fourth issue I like to address is this. Simple. It's a very simple matter. You see, the legal vacation. What is it? The legal vacation is not a compulsory vacation for the bar. It is not and cannot be. You understand? The legal vacation is actually, from what I have read, a vacation for High Court, for the High Court. That's what I've read. Okay? But be that it is made, throughout our history, courts have sat during the legal vacation. And many cases have been cited. I'm not going to waste my time citing the cases. Courts have sat during the legal vacation. It's not unusual for courts to sit during the legal vacation. It is indeed normal. But if you look at the administrative practice, it is even more interesting. You see, the current legal vacation, I think, starts from 1st August and ends on the 30th of September. Now, the regulations, the law and so on, allows the Chief Justice to designate some judges as vacation judges. Now, those judges are allowed or can continue with cases before them and deal with cases which would otherwise have gone to non-vacation judges, especially when they are deemed to be important, when they relate to the rights of accused persons and so on. You understand? And the lawyers call them injunctions and so on and so on. You understand? So that is the practice. Now what is interesting is that the vacation judges who are sitting during the vacation are also entitled to their vacation. So after 30th of September, the vacation judges will take 2 months vacation. Are you listening to me very carefully? Now that means that if you say today that the judges should suspend the cases before them because the courts are on vacation, it means that the cases before the judges will be delayed for 4 months. Because they're saying that between now, 1st August and 30th September, the cases must not be heard. Now, after 30th September, the judges will take their own vacation, which they were denied during the vacation period, for another 2 months. So you are saying that the cases before the courts should be adjourned for 4 months. I mean, this is incredible. It's clearly incredible. Now, Senna, and today I've remembered to mention your true name, Senna. You see, when a case is before a court, that case does not just concern the accused person. I'm talking about a criminal case. Okay? Let's say that a criminal case like rape is before the courts. The parties in the case would include the state represented by the Attorney General or his representative. The Constitution imposes certain duties on the Attorney General. It's a party to the case. The person, the rape victim, is a party to the case and has an interest in the case. The family of the rape victim is a party to the case and has an interest in the case. In some cases, the community in which the victim of the crime comes from has an interest in the case. And the state, as the state of Ghana, has an interest in the case. You understand? So there are so many interests in any particular case. For example, if you take the case of corruption, it's a case that affects everybody. And indeed, it's important that all interest in the case must be recognized and respected. You see? That is why the legal principle of the purposive interpretation of the law makes sense. The principle of the purposive interpretation of the law means that the law must not be interpreted in such a manner as would disrupt the functioning of society. The law must not be interpreted in such a manner as would dislodge the society in any way. You understand what I'm saying? And that's a recognition that in interpreting the law, there are so many interests, so many parties and so on in the process who will be affected by the interpretation of the law. So to argue that only lawyers representing clients in criminal trials, only their interest must be taken into account, I think is to disrespect the law and the practice of the law. You understand what I'm saying? Because how come? Let's take the case of the trial of anybody who Edubuahini and so on. Edubuahini is in court. It means that he has agreed to comply with the rules and so on, the position of the court. His lawyer says, I'm not going to court. The Attorney General representing the state is ready to go to court and so on. The judge presiding over the case is in court. Now, should all the other interests be subordinated to the interest of the counsel representing the accused person? I doubt. I have my doubts. You understand? Now, from this position, another position emerges. And it is simply this. Who determines? Who determines when the judiciary, or when, if you like, for a broader term, the bench should sit in adjudication over matters? Who decides? Ultimately, that power from practice has been with the bench. From time immemorial, the power to decide when a court should sit or not sit is a prerogative of the bench, not the bar. But we have a case where now the bar is actually seeking to dictate when the court should sit. And that is an aberration, clear aberration. You understand? Now, I'm looking at the arguments that are flowing around, and I am completely shocked by an aspect of this debate. I am so very shocked. Why? The right to speedy trial is recognized in all jurisdictions. That accused persons have a right to speedy trial. And indeed, accused persons normally insist on speedy trial. Because the delays in trials are expensive. The delays in trials are inconvenient in many ways for accused persons. This is one of the very few cases where I'm hearing accused persons say that, look, I want you to delay my case. What advantage would the accused persons get? Lawyers for the accused persons say, don't speed up the trial. Slow it down. Delay it for 4 months. Delay the case for 4 months. Why? Now, the right to speedy trial is being trampled under the feet of counsel for accused persons. And persons who claim to be acting in the interest of accused persons are trampling on the right to speedy trial. And I cannot understand it. I'm totally confused. Now I want to ask a few questions. Senna, just imagine that these lawyers who are making noises about their vacation and so on, just imagine that their clients were not on bail and were actually in prison. What would their conduct amount to? Their conduct would amount to keeping their clients and assuming that their clients eventually will be found innocent. Their conduct would amount to keeping their clients in jail for crimes they have not committed. Is that what the legal profession is about? Just imagine. Now just imagine that these lawyers had clients whose rights are clearly being abused. And they say, look, I want to go on vacation. I want to rest. I want to go to Dodi Island and take a boat and swing small and so on. So wait for 4 months. Is that a responsible behavior for lawyers? Just imagine that the lives of their clients were in jeopardy in one way or the other. Would they not be rushing to the courts to ensure that the right of speedy trial is enforced? I can't believe it. This is one of the very few occasions in my life that I have rather seen the prosecution and the bench insist on the right of speedy trial and accused persons and their lawyers are saying, no, don't try us so fast, we want to delay. Please delay, don't try us so fast, don't establish our innocence now. Wait for 4 months to establish our innocence. I can't believe it. But that is the argument they are putting forward. The argument they are putting forward is that, look, I am innocent. I haven't committed any act of corruption. The facts, the evidence will bear that out. But don't come to that conclusion now. Wait for 4 months before you come to that conclusion. How does that make sense? How does that make sense? Master, I think we are getting tired, and I'm not the only one. There are so many people in this population who are getting tired of the antics of some of our politicians, especially those politicians who say that facts should not matter. That facts should not matter at all. And that all of our communications, all of our debates should be engrossed in pure, empty propaganda. The people of Ghana are listening, the people of Ghana are watching, and the people of Ghana are making their judgments about who is protecting their interests and who is taking them for a ride. I have finished.
Manever I say PENDREAM TV. PENDREAM TV there, I see them yopo.